Just like we always do, we're going to start the show with an email question. We have an email, I believe, that came in from Allie. Can we put that up? Okay, Allie said, I was backing out of a parking spot and another car backed into me, but now I can't get the other driver to call me back. My insurer hasn't done much to help. What should I do?
Sounds like they're doing the old head in the sand approach.
That's exactly
when
right.
all fails, just don't make eye contact and hope it'll go away. And,
that's right. Unfortunately, that doesn't really work for most people if they do cause a wreck. But Ted, what does Allie do in a situation like that? You know, a parking lot collisions are pretty common around here. People backing out at the same time. You know, it's minor. It's probably not involving an injury, but it's inconvenient. So what should Allie do in that situation?
And you know, one issue also when we have sometimes with the parking lots is you can't get the police sometimes to come out to do a report. If it's on private property, sometimes it can be difficult to get that properly documented and some of the things that you would typically see in a normal claim that's on the highway or the roads. But when you don't have someone that's communicating with you, obviously that's the first step. You got to make eye contact and you got to get the process started. So what I would suggest and I would highly recommend is that you reach out to an attorney to assist you with that, because there are tools in the toolbox that you can make someone respond to you if they will not communicate with you. Obviously, the first step we always try to take is to see if we can resolve something amicably. We go through the claims process. We try to negotiate with the insurance company for the at-fault party in this particular case, and try to seek a resolution, whether that be for property damage or bodily injury, depending on the particular circumstances. Like Les said, if this is in a parking lot, it's likely that you're dealing more with property damage than you are bodily injuries. But if you can't even get them to respond to you, you don't know what the information, you can't open the claim, what you have to do is we have to take it to the courthouse if you can't get someone to speak with you, and that will force the issue and allow you to ultimately get some relief. If, for example, maybe they don't have coverage, and you can still go forward and get a judgment against this particular person to compensate you for whatever your injuries may be. But when someone won't talk to you, we will talk to you and we'll make sure that you can get through that process.
Yeah, it's always very frustrating whenever people get involved in the claim process, because they really don't know what to do at the very beginning. And you know, if you're dealing with an injury, obviously the most important thing is to make sure that you get the necessary medical treatment to make sure that you're okay. But beyond that, I mean, it's getting all the information, calling law enforcement, taking down names, getting photographs, anything that you might need later on to prove your case. Those are all very important things. And if you wait, if you don't think about, you know, how do I preserve this? How do I protect myself? Then if you wait 2 or 3 days, a week or so, oftentimes, you know, you may not be able to find a witness. The scene may have changed. If there were, you know, if this was a case involving skid marks and it's rained and now everything's gone, you could absolutely lose evidence. So getting somebody out to the scene, getting a lawyer involved very early on would be very helpful in making sure that you've protected your rights.
Right. Unless also that person that was at fault, it's important that they report that claim and cooperate with their insurance company as well, because hopefully they have purchased a policy that will provide them with coverage in order to protect them from this case, but they have a duty and obligation under the terms of their policy to cooperate with their insurance company and provide them notice of what's going on so that they can investigate it and resolve the claim, hopefully without having to file a lawsuit. You know,
Ted, that brings up a great point. You know, we talk about, on this show, we talk about people that have been the victims of an accident or some sort of an injury that's happened to them because of somebody else's negligence. But what if you are the person that is negligent? It's you know, when we talk about negligence on the show, we're not talking about, you know, people doing things that are evil or bad. They're mistakes. They're careless mistakes. I mean, that's the definition of negligence in Florida, is failing to do what a reasonably prudent person would do in like circumstances. And so if you're driving down the road and you're not paying attention and you hit someone, you could be negligent. If you're, you know, fiddling with your phone or going to grab a drink or just take your eyes off the road, you can be negligent. You're not intending to hurt somebody, but you can certainly be held liable under Florida's civil laws. Now, if you are one of those people that causes a wreck, you know, Ted, we talk to people all the time and they say, well, the other side's insurance company doesn't know anything about it. And we oftentimes have to initiate the claim with the other person's insurance. If somebody causes a wreck, what should they do in order to protect themselves? Because even people that cause wrecks, they still have rights and they still have obligations, right?
Right, and hopefully they've bought protection. I mean, what is automobile insurance? What is any insurance? It's protection against risk. And you know, and that's we get often asked, You know, how much coverage should I buy? How much of this should I take care of? What kinds of coverages should I have? And that's all very specific based off of your personal assets, what you do, how often you're driving. A lot of different variables go into that equation. But if you're in an accident, it's important that you put your insurance carrier on notice so that they can properly investigate it and protect you and try to resolve that claim as quickly and expeditiously as possible, because your liability is not limited by the amount of coverage you have. For example, if you have an accident, you pull out in a pedestrian and you hit them and severely injure them and hospitalize them, and you only have a $50,000 policy, that is not enough coverage to compensate that person for the damages that they've experienced, both from a medical perspective, from a lost wage, from pain and suffering. So it's important that you have your insurance company quickly on a case, that example or any example, so that they can try to resolve the case, unless this is something we see every day where the insurance companies sometimes get involved and they drag their fee and don't try to resolve the case, and then that potentially can lead to a situation under Florida law, which we refer to as bad faith, where the policy limits can potentially become irrelevant. And if you want to speak about that just briefly.
Sure. Yeah, wanted to touch on real quick something you said before about putting your insurance company on notice if you are the one that causes a wreck. It's not just a good idea to do that, it's actually a requirement that you do that. Because an insurance policy is nothing more than a contract. You're paying an amount of money to an insurance company. They are providing you with a policy. That policy is a contract. It says if you pay me premium, if something happens, if some insurable risk occurs, we will cover you. We will provide you with an attorney. We will pay for the cost of your defense. If we have to pay a judgment, we will pay a judgment up to whatever our coverage limits are. And there's different types of coverages that you have. And so in order for an insurance company to step up and honor their end of the deal, they have to be put on notice. And if they're not put on notice timely, if you wait and wait and wait, then the insurance company can step back and go, hey, you know, if you'd have told us that this happened when it happened, we could have gotten out in front of this. We could have resolved the case. We could have done this. We could have maybe saved a bunch of money. We could have saved a bunch of time and energy. But because you waited so long, you have actually prejudiced us. Did I say that right? Is that a word? Prejudiced us. And so we can't effectively defend you. And in that case, an insurance company can say, you know, we're not going to provide coverage. So you could have a policy, but if you don't uphold your end of the deal and putting them on notice, the insurance company can say, hey, you know, too bad. Now, Ted, getting back to your talking about bad faith, I mean, you know, we talk about insurance limits, and you know, and we've talked about it on the show on and on and on again about the importance of things like uninsured motorist coverage, because in the state of Florida, if you are going to be hit by somebody, chances are you're going to get hit by somebody that either does not have bodily injury liability coverage, or they have the bare minimum amount of coverage that's required by Florida law, which is $10,000 of PIP, which doesn't compensate the injured party that was injured by someone's negligence, and then property damage coverage. So you need to buy uninsured motorist coverage, because that's the coverage that you can tap into in the event you're hit by somebody that doesn't have that coverage or doesn't have enough to fully compensate you. But if an insurance company has all the facts before them and they don't do the right thing, then they can be held in bad faith. And there's two types of bad faith in Florida. I'll talk about the first party type of bad faith, and then I'll let Teddy Ballgame over there tell us about third party bad faith. But when we talk about first party bad faith, this is the type of thing we see most common, for example, in hurricane claims. A first party bad faith claim is a claim by you against your own insurance company for them not doing what they're supposed to do, whether it's to protect you, whether it's to fully compensate you for the benefits that you're entitled to. And if you give your insurance company an opportunity and you follow the steps and you get a lawyer involved and they do what's called a civil remedy notice and you give the insurance company time to cure their mistake, if they don't do that, then you can be in a situation where your policy limits are removed and the insurance company can be on the hook for whatever your total damages are, irregardless of what your coverage limits are. Now, that's in a first party context when it's your own insurance company. But Ted, oftentimes we deal with third party, probably more times than not, we deal with third party bad faith when we're representing injured people. How does that work?
Yes, and that's the one that we more frequently see day to day in our practice. And third party bad faith is a situation where the person that has caused the accident has a certain level of insurance. Like my example from earlier, the individual that hits the pedestrian and places them in the hospital. And for example, if that individual that caused that accident only had $50,000 in coverage, that's clearly inadequate to compensate that person who has been hospitalized with severe injuries. So if the insurance company that is representing that at-fault person in that situation has reasonable time to investigate that claim and fails to, within a reasonable amount of time, tender those limits in order to try to protect the third party in that situation, then that's a scenario where that insurance company can potentially become liable for the full extent of the damages. It's a duty to investigate reasonably based off of the information they have at the time, and it's a fiduciary responsibility of that insurance company. And if they do not take those reasonable steps with that information timely, then potentially their exposure is not limited by the coverage that was actually purchased.